So lovely to meet all of you again on a Thursday evening. I think we have some repeat audience as well. And for all of you who have joined us for the first time, happy evening to all of you. Welcome to yet another wonderful session from Team LO. This is the third session that we are having with them. And can't wait to listen to Aditi and whatever she's going to talk today, because for all of you who are new to today's session, to just give a brief about Aditi. Aditi heads the legal wing of LO, and she's an expert and has more than about 12 plus years of experience working with various lawsuits, as well as law firms, as well as financial institutions, and she's an expert in preparing the wills, and also she gives a considerable time in educating people about the importance of will creation, especially to women. And today's session is very, very special because in today's session, she's also going to enlighten us about, what are the measures that we will have to take after our, on our assets, so that the assets get transferred to the right legal heirs of us. And she's also going to throw some light on the difference between the nominees and the legal heirs. And a lot of interesting things that we are looking forward to hear from Aditi. And quickly, before we start on the session, let me ask some icebreaker questions. Okay, so here are the questions. Are you aware of the concept of nomination? So you can type in your answers in the chat box. I repeat the question. Are you aware of the concept of nomination? I'm sure all of us know that we always enter that name, right? Some nominee's name. But do we know what the concept is all about? That's the question. Great. So I see the answers coming in. So many of us have said yes. Great. So I think, Aditi, your job is going to be simpler. So we have good audience who are already aware about what a nominee is all about. Great. Okay, so here we go with the second question. Do you think estate planning is essential? I repeat, do you think estate planning is essential? So Revati says yes, very much Revati. Sujata says yes, yes. Okay, people bring it in. Not sure. It's fine, Nirmala. I think after Aditi's session, we will have a lot of insights on what we need to do.
Yes, you'll have a lot of clarity, hopefully.
Yes. So that's about the icebreaker questions, and I'm quickly going to launch the poll for people to. So here is the poll. So the poll really help us to structure the sessions much better. So please do answer this poll whenever we launch it. So the first question for today's poll is, do you think a will is required even if one has a nominee? So we have answers coming in. There are people who are saying, yes, I think a will is required even if one already has no nominee. And we have people saying, I'm new to this topic and would like to learn more. Yes, you're in the right place. And we also have people telling, no, I think one can do without a will. So there are about 33% of people who believe that, no, I think one can do without a will. So let's figure it out what Aditi has to say at the end of this session. Thank you all, and over to you, Aditi.
Thank you. Thank you so much, Vidya. And it's always amazing to talk to the amazing women of Aspire for Her. And to be very honest, we look forward to these sessions And I was talking to Vidya, we don't realize when time just passes by and the time comes again for a session with you all. Thank you once again for a very warm welcome. And yes, as you ladies rightly pointed out, you're here at the right place, and we'll figure out together what happens when you have a will and what happens when you don't have a will. With that, I'll just share my screen. Okay, I think you're able to see my screen now. Okay. Akansha, can you just give a thumbs up if you're able to see my screen correctly?
Yes, yes, Aditi, we are able to see you.
I can see your screen, Aditi.
Okay, thank you so much. All right. So today we're going to be talking about the basics of asset transfer. Essentially, what asset transfer means is that once we have any asset, or once our parents or our near and dear ones have any asset, that asset is going to pass on to someone. So today we'll be figuring out how an asset really transfers. We'll also see how nomination becomes so important in light of asset transfer. And we'll also talk about what are the different misconceptions that people have regarding a will, because a will is an important part of asset transfer. And of course, needless to mention, I'll also talk about what are some tips that as women we need to bear in mind. And I'll take a few minutes and talk a little bit about Yellow, who we are, and what is our passion, and what is it that we want to share with you. Okay, moving on. Now I'll cover a little bit of journey about the basics. This is for all the ladies who either have newly joined in or have not been able to be a part of the earlier session. So I'll take around 5 minutes to just cover, it'll be like a quick recap so that we're all on the same page when we're dealing with the slides now. So essentially, there are certain problems which are plaguing the Indian society today. There are 150,000 crores of assets which are unclaimed. This is largely because one is we don't even know those assets exist. Like we don't know, right? Our parents bank with which institution? We don't know. Do we know how many fixed deposits our parents own? We don't know. So naturally, if they're not there anymore, we don't really go and claim what belongs to us. Secondly, also, the process of claiming assets is complicated. Because of that also, sometimes we don't end up claiming assets. Now, typically, when a person does not leave behind a will, it takes around 3 years, if you're lucky, and if there's no dispute, to get all the asset transfers done. Also today, around 75% of the cases in Indian courts are burdened because of family and property disputes. And we'll see shortly how, if we simply make a will, these numbers can be reduced. And lastly, I'll touch upon, there are some tools which are available with us today where we can plan your estate. I'll briefly touch upon the tools so that you're aware of what is right for you. So firstly is a will. A will is a very simple document in which you write down what your assets are and you write down who those assets are to be passed on to. Secondly, you have a trust structure. It's a little bit of a sophisticated structure where if you have certain specific purposes, for example, if you have a child with special needs, or if there are business families who want to consolidate assets, or there are some situations where you have citizenship of several countries. Example, if your daughter is a citizen of a particular country, if your son is a citizen of a particular nation, then trust structures can be useful. The third one is called as a gift. As the word rightly says, you give something which belongs to you to someone, your ownership ceases. For example, if I have to gift a house to Vidya, I will stop being the owner of that particular house, and the house will now belong to Vidya. You may have commonly heard in India during marriages, especially, a lot of this gifting happens. But it is definitely a tool of estate planning, but it can't be the only tool you use, because naturally, while we're around, we need some assets to be with us for our own upkeep. Nextly, you have the nomination aspect. I'll cover in detail about what a nominee is, but I'll just briefly mention. You may have seen when you're opening a bank account, somebody asks you to mention a nominee. And when you tell when you ask the accountant that, what is the role of a nominee? He simply tells you, nominee will receive your assets when you're not there anymore. He is only partly right, because if you go to the next level, a nominee does receive everything only to hold it for the benefit of the correct legal heirs. I know for some of you who are new to this session, these concepts may seem a little overwhelming, but trust me, as we'll pass on in the presentation, you will be well equipped with what each of these means. And lastly, you have the right of survivorship. This means that certain cases you may have a bank account. Let's say you jointly own it with someone, and in that particular bank account, you may have heard of the words either or survivor. So this means if one person is not there anymore, the survivor receives the amount. So this is a basic overview of what we've seen in the last two sessions. And I'll also touch upon why is it important to make a will. So you'll exactly know that since will is one of the modes of asset transfer, how is it relevant for today? So firstly, like I mentioned, it's a very basic and an important step towards an estate plan. So even if you adopt any other method, for example, a trust, you create a trust, or you gift your property, or let's say you've mentioned either a survivor in a bank account, anything is incomplete without a will, because you will need a will as long as you are alive. And one of the most important aspects of a will is that you don't lose control over your assets. So I'll give you a difference between the control aspect. Let's say if I mention in my will, my house will go to Vidya when I'm not there anymore, which means Vidya will receive the house only when I'm not there. And it's really easy for me to change the will. I can amend my will anytime and mention that Indu will get my house or Akansha will get my house. However, if I gift the house to Vidya, Vidya will receive the day I sign that particular gift deed. And hence, while we are alive, the will gives us entire control and we don't lose any control over our assets. Secondly, a will helps us to bypass laws of intestate succession. What this means is, when we are not around, and let's say we don't leave behind a will, our religious laws govern who the assets will go on to. To give you an example, if I am a Hindu female and if I am not around, my husband and my children receive the assets. So there are similar laws for Christians, laws for Muslims, laws for Parsis. These laws govern once we are not there anymore. They decide who are those relatives which are mentioned in your laws. They receive the assets. As opposed to a will, we can choose who the assets to go to. Thirdly, the asset transfer becomes very smooth. So today's session is largely focused on asset transfer. So we'll see shortly how asset transfer becomes very easy when you have a will. Also, you saw earlier how I mentioned 1,50,000 crores of assets are unclaimed. However, that is also largely because we don't even know what assets our families own. And a will becomes like your asset register. So you mention in the will, this is a bank account. You can mention the last 4 digits and the branch name. That's good enough, for us to identify the assets. We don't need to write the amount of money which is there in your bank account, because that as it is changes from time to time. Also, when you have a will, there's a clear sense of direction which is there. And because of that, it helps in preventing disputes. A will is also a very important document, especially for mothers who have minor children. You can actually appoint a guardian to take care of your children. And lastly, you can choose who should inherit what asset. Let's say you have a child who has a musical bent of mind. You can choose that that particular child will receive the piano that you have. Or let's say you have a niece who's academically brilliant but does not have the necessary means to pursue education. You can allocate a small amount or whatever amount you want in your will. But that is not possible if you don't have a will, because your immediate relatives, which the law defines, they get your assets. We'll move on. Some of these popular misconceptions which we're going to be debunking. People think that they should write a will only when they're old or only when they're not well. Or people think, I'm not super rich, why do I need a will? Now, let me tell you, COVID has taught us that life is uncertain. So you should make a will today and not wait for to reach a certain age. Also, the existence of an asset is important, not the quantity of it. Even if you have a certain amount in your bank account, it has to go to someone when we're not there anymore. So all of these aspects are taken care of simply by a will. I mentioned earlier, all your assets need not go only to your spouse if you're not there anymore. It depends on the list of relatives which are there. See, for example, in Christians, you have spouse and they've defined a term called lineal descendants, which means children. If children are not there, grandchildren. In case of a Muslim family, the laws also depend on which sect you belong to. But in that case also, the sister inherits a portion, the brother inherits a portion. Generally, women get half of what the male counterparts get. In some cases, grandparents also inherit. So all these, your relatives, the law decides and you don't. Also, you don't lose control over your assets at all. It's very, very easy to change your will as many times as possible. In fact, the law itself says that by tearing up a will, it's as good as the will not being there anymore. And lastly, like I mentioned, appointing a nominee is not the same as mentioning a beneficiary in a will, and you'll very soon find out why. So we'll pause here for some questions. I know for some of you who've not been attending for the last 2 sessions, it may seem a lot, but I'm more than happy to answer any queries which you may have. Any questions so far?
If you have any questions, you can unmute yourself, or you can also type it in the chat box.
Yes. So Revati is asking what happens if someone has no immediate relatives. So Revati, actually, to give you an example, Hindu Succession Act governs Hindu women. So firstly, you have class 1S. So they've mentioned who all are class 1S, and they've mentioned the order. And you also have class 2S. So then, people on your father's side, your mother's side, they've all given a proper list. So if you don't have immediate relatives, for example, if somebody is not married, or if somebody had a separation, everything is properly mentioned in the law. And lastly, if there is no class 1S, if there's no class 2S, then the government gets the property. So essentially, the property goes to someone or the other. and lastly, it will go to the government. So we'll have to check what, what faith you belong to, and accordingly see the relatives. Nitya mentioned, what if the inheritance is an HUF property? So Nitya, the Hindu law also provides that if you have any share in an HUF property, that also can be mentioned in the will. And otherwise, like we've seen, if there is no will, then it will go as per your usual laws of inheritance. Any other questions?
Aditi, we have one question since we are live streaming here. There is a question in the LinkedIn from Bharti Megnani. Last point about nominee. Please explain this.
Okay, so Bharti, if you can wait for 2 more minutes while we address this, because this session is going to be nominee centric, and I assure you I will resolve all your doubts in the next 5 minutes.
So we have another question from Revati. What is the process for leaving some assets to a charity of our choice?
So Revati, interestingly, you can also mention this in your will, that let's say there's a certain educational organization, or there's an organization which takes care of, animal rights. You can simply mention in your will that this particular portion of, my assets should go to charity. However, if you don't have a will, then this will not be possible, because everything will go to the relatives as per law. So if you have, some aim or some desire about charity, then you must write a will. Okay. I think we can move on, and we can take the next set of questions shortly.
Yes.
Okay. So let's understand this aspect of asset transfers and the beneficiaries. Now, nomination becomes very, very important even in the asset transfer aspect. Now, let's understand who a nominee really is and what are the powers of a nominee. Now, if I mention that my mother is the nominee of my asset today, what this simply means, in the event of my demise, my mother will go and receive that particular asset only to distribute it to rightful heirs. What this really means is that, now let's say today I am a Hindu, and let's say as per Hindu law, the succession, let's say if I've not written a will, my husband and my children and my husband and my children are the rightful heirs, which means even though my mother is mentioned as a nominee, my mother is to collect those assets and give it to my husband and my children. That is exactly how a nominee operates. Now, I'll just divide that nominee part into 2 aspects. Now, that is a general law of nomination. So let's see the general law, and then we'll see a few exceptions. So if you have a bank account, if you have a fixed deposit, recurring deposit, or if you have a locker, jewelry which you may have, any national savings certificates or any other instrument you've taken under a post office scheme, public provident fund, don't confuse this with your employee provident fund, a public provident fund, or let's say you're entitled to a gratuity from your company, any immovable property, your land, flat, a home, or a flat in a cooperative housing society, or anything you're dealing with, shares, mutual funds, whatever securities you have, your demat or your trading account. Now, for all of these 7 squares that you can see, those inheritances are governed by your beneficiary in the will, which means even if you've mentioned a nominee for each of these assets, your nominee is added only for the purpose of convenience. Now, people ask, if the nominee is not supposed to, take benefits, why even add a nominee? See, for a bank, it's very hard for them to ascertain who your rightful heirs are, correct? So for any institution, for them, it becomes a good act if they hand over the amount to that particular nominee. So to say, it's a valid discharge for them. Then the nominee can decide who that amount is to go to. Hence, you must remember for these 7 categories, the nominee is added only for the sake of convenience. But the beneficiary in your will becomes the ultimate owner. Now, how do we align this whole bit? Let's say my bank account, I want my entire bank account proceeds to go to my husband. In that case, my nominee, it is recommended that I also mention my husband as a nominee. Naturally, when we all start working, we're fairly young, 23, 24, and most of us may not have been married at that time. In that case, we can, we usually add our parents. But it's very important to update it because most of us don't update our nominees at all. I do understand in our chaotic lives, this becomes the last priority, but this becomes very, very important for you to update your nominee and align it with your beneficiary. Now, what happens if you don't have a will? In that case, your nominee is supposed to collect that amount and distribute it to your legal heirs. That is the same relatives which your law specifies about. So I'll give you 2 examples again. Let's say I have not left behind a will, and let's say my mother is the nominee. In that case, my mother is supposed to collect that amount and give it to my husband and my children. However, if there's a will, and let's say my husband is mentioned as a beneficiary, and let's say I've not updated my nominee, in that case also, my mother is supposed to collect the assets and give it to my husband. But obviously, what is the easiest thing to do? To make my husband as a nominee so that my husband can simply go and collect what is due to him. Are we clear on this? If there are any questions, I'm actually happy to answer. Are we all clear on the role of a nominee? Okay.
We have 2 questions in the chat.
Yeah.
So there is first is what if there's no will, but there is a nominee?
Okay. So Nitya, I mentioned if you don't have a will, and if you have a nominee, your nominee is supposed to collect it and give it to your legal heirs. Like I mentioned, if my mom is a nominee, then my mom is going to collect it and pass it on to my husband and children.
The next question she's asked is, and do children claim expenses medically spent on parents from their parents' assets?
Essentially, what you're talking about, I think, is from the okay. Let's say they were in a hospital and let's say they passed away. And let's say there is a will which is there in place. So generally, we mention in the will that all the debts and outstandings and expenses are to be covered and paid off from the parents' assets, and only then will the assets be distributed. So to answer your question, in that broad sense, we do usually mention in the will expenses and loans are to be paid off first, and then the distribution is going to happen.
We have another question. It says, if there is no nominee, but there is a will, what happens in that case?
Okay. Now, if there's no nominee and if there's a will, then essentially the beneficiary under the will is to go submit a copy of the will, and then the bank will do all the verification and then you'll receive the assets. So I'll cover this aspect too, transfers with a will and without a will. I'll cover that too. Okay. So we'll now see the second batch. Now, I know that this was not really simple, but I'm going to complicate it just a little bit more for you here. this is what we discussed right now is a general law of nomination. However, there are some exceptions to this rule. In case of insurance, in case of an employee provident fund, and in case of a pension and vehicle, your nominee becomes the ultimate beneficiary, which means even if you've mentioned something in the will, your nomination is going to override. What is the rationale behind it? I genuinely do not know. Because if you were to ask me, these assets ideally should all the family should receive. But however, currently that is what the situation is. In case of these aspects, your nominee becomes important. And that is why, again, there's a simple solution to this. Let's try and align our nominations with our intentions. If you intend that your sister should receive something, make your sister the nominee. If you intend that your sister and your brother should receive, let's say, 50% of a particular bank account, make them the nominees. So that asset transfer becomes easier. And obviously, there is no chance of any dispute which may have arisen. Because a situation may arise, right? Let's say in your will, you've mentioned your sister and your brother should receive something, but let's say you've made your husband as a nominee. Now, for your brother and sister to claim something, they need to, hopefully they should be on good terms with your husband, so that the asset transfer becomes smooth. However, it's always good to nations. This is an interesting aspect that the law has covered. If you get married, your nomination actually becomes invalid. So hence, like I mentioned, the crux, the solution of all of this is update your nominee from time to time. Okay, we'll move on. What are the various methods of asset transfer? See, essentially any asset which is there are two routes. Either it will go under a will or it will go without a will. Under a will method is obviously simpler, but let's see what are the complications that come in when you don't have a will. See, essentially, it's actually very logical. If there is no will, the bank or the financial institution or the mutual fund house, how do they really know that you are entitled to that particular amount, especially when nominee is not there? So they ask you to submit certain documents which you have to get from the court. So most popular is a legal heir certificate, or it's called as a family tree. You submit that, and you also have to submit the relatives have to submit an indemnity bond or a no objection certificate. You obviously need to submit a death certificate. There are some claim forms which which vary from institution to institution. The bigger challenge comes not from family members or a batch of people which are for your laws. Not very common. Some disputes have arisen, and now it becomes a part of that 1,50,000 crores. So because of that, these processes become very, very complicated. I'll touch
Aditi, if I can just interrupt you. There is a lag in your voice.
Yes, please.
Okay. So there is a lag. We lost you in between.
Okay, can you hear me correctly now?
Yes, it's better.
Okay, great. Thank you. So I'll just go a few sentences back. So essentially, a family tree or a legal heir certificate have many. If there is a little bit of dispute between the relatives, then it becomes all the more difficult for you to obtain, the various no objections and all those aspects. I'll also touch upon the succession certificate aspect. Essentially, for certain purposes, especially if there are loans which are due, then need to obtain a succession certificate. Again, I'll not get into the technicalities, but just remember that if you don't leave behind a will, all these aspects need to be looked into. Moving on, how does the asset transfer look like when you have a will in place? Essentially, the executor, which is appointed and large. So he essentially is, he has a responsibility to make sure all your wishes under the will are carried out. So once that is done, distribution of the beneficiaries takes place. Now, there are certain common documents which are required. One is death certificate of the testator. You need to submit a copy of the will, ID proofs of the beneficiaries and ID proofs of the nominee. And every institution will have its own formalities. And lastly, so a claim form may be involved. And lastly, if there's any immovable property which is there, then you may need a property registration certificate, and there are some formalities. But essentially, it becomes very clear that the rightful owner is clearly mentioned in the will. Okay. A few interesting facts. So there's a concept called as probate. Probate really means that you need to go to the court to actually make sure that the will is certified and the will is genuine. But the probate process is only required in Mumbai, Kolkata, and Chennai. And if there's any immovable property in either of these places. Legal heir certificate is known under various names. For example, Pedinama certificate in Gujarat, Varasu certificate in Tamil Nadu. You can see surviving member certificate in Delhi and the family member certificate in UP. So a lot of different names, but essentially they all serve the same purpose. Pets, a lot of us have pets. And unfortunately in India, you cannot directly make pets as beneficiaries because as per law, beneficiaries are required to be people who can hold property. So because of that, pets are considered assets. However, there are several routes through which you can take care of your pets. You can appoint a pet guardian, or you can appoint a trustee under a trust who's going to take care of your pets. Now, this concept of probate is not new only to India. You have the concept of probate in UK, US, Canada, Australia, and New Zealand too. And lastly, in this whole asset transfer fun facts, it's also good and helpful if you register a will, because that registration will help with ease of asset transfer, because sometimes some corporations, especially when they are transferring immovable property, they require a registered copy of the will. So although the law does not require it, however, it's good if you have it done. And just another practical aspect I want to point out, registering a will is not expensive. In Bangalore, you can do it for 5,000 rupees. Bombay, somewhere between 7 to 10K, and roughly in the same range across India. Okay, some important tips to bear in mind. I especially want to point out the very first aspect. Please keep your identity proofs updated. We have a client who came up to us shortly, and he's like, he had 7 different variations of his name. To protect confidentiality, I'm not going to reveal his real name. But, to give you an example, he was Venkat S in one document, Venkata Raman S in one document, Venkat Raman in one, Venkat in one. So there were 7 different variations. So, the first thing we did was we told him that, look, to get an affidavit and just say that all of these are the same people as you, have it published in the Gazette. Again, all of these do take some time, but it's not an expensive process, like a few thousands, and you'll have your issues sorted, rather than waiting for your family to tear their hair apart and just see that what mess has been made of something which can be so simply rectified. So just make sure that your Aadhaar is in line with your PAN, and etc., etc. Start planning now, because today you're in charge of your assets. You should make sure that you plan well in advance, thinking of your loved ones, because essentially we're doing all of this today only to protect our loved ones. And as women, this is our second nature. So we must be very cautious. Take out time from your busy lives and plan this out. Add clear details in your will. For example, if you have 2 nieces, both named Radhika, one on your mom's side, one on your dad's side, just write the surname as well so that there's no confusion. It's also good practice to keep your family informed about the will that you've made. I've mentioned this earlier. Get your will registered, especially if you're dealing with immovable property, and also update your will from time to time. It's good to check for tax implications, especially if you're a resident, if you're a citizen and resident of another country. It's good to appoint an executor under your will, because if you don't, again, you need to go to court if nobody's taking up the responsibility to get it sorted. And lastly, please ensure that your nominations are updated. Any questions?
Aditi, lots of questions.
Wow.
So they've asked, I'll just have to scroll up a bit. So I think it's from the nomination side. What is the process for HUF property?
Okay, so see, for HUF property, you'll not have any nomination, because your HUF property is owned by a pool of people. So HUF, you can't really nominate, because all of them will have a share in that particular property. However, you'll be able to will it your share as per the will. Okay.
Yeah.
So Geeta says, nominee, legal heir, executor, can all 3 be the same person? So essentially, yes, because the person who you appoint as a nominee can be your beneficiary under a will. And definitely, let's say if that person is your spouse, it's good to appoint your spouse as the executor, because then the spouse will be able to manage everything very smoothly from an operational standpoint. So there is no bar on all of them being the same person. Okay, how could NRIs get a will? So actually for NRIs, I would recommend that you make one will for your Indian assets, which is compliant with the India-related processes and procedures. Also get a separate will for any assets you own abroad. I'll give you an example. Let's say if you own a flat in Dubai, Dubai requires you to register your will under a body called a DIFC. So because these small, jurisdictional aspects are there, local processes are there, it's good to have a separate will for your assets you own abroad and a separate will for your India assets. Also, the execution becomes much easier. Okay, every time one changes the will, do you need to register it? If you have registered your previous will, then yes. But otherwise, see, it's a recommended, it's a practice that is recommended, but it's not mandatory. But if you're dealing with immovable property, it's good to get it registered. If you register a will and later changed it, but did not register the updated one, will the previous one be considered or the later one? Always the later one will prevail and not your previous will. And it's always good to also mention in the last will that you're writing, rather the later version, to mention that all my previous wills don't hold good, or all my previous wills are become null and void. So all those languages incorporated also really help. Revati mentions, if someone in India wishes to leave their property to someone in another country, does will have to be registered in both countries? The answer is no. Only the place in which your property is situated, there you should go and get it registered. Where the beneficiary resides will have no correlation to the registration of your will. Can will be made in HUF? Can a co-partner be removed? Actually, a co-partner can't be removed through a will. A co-partner can be removed only if there are certain conditions. Let's say co-partner is not of a mental sanity anymore, or let's say there's some fraud which took place, or let's say he disposed of the assets without a good reason. But then you have to go to court to get all those aspects sorted out. But otherwise, your share in the HUF you can will. So we generally mention my share in this so-and-so ancestral property can be willed. Okay. Maria is asking, if I make a person one as the guardian appointee for my minor children, how can I make sure the money is used for my kids? Can I ask the executor to invest the money for my kids? Definitely. See, in such a situation, Maria, to be honest, as opposed to a will, a trust will be a better option, because in a trust, you can choose staggered payments. For example, you can choose, if my children turn 25, they will receive, for example, 1 lakh rupee a month. Or let's say if my children turn 30, they should receive 2 lakh rupees. So staggered payments and this whole investment aspect is possible for a trust. With a will, it's a little difficult to practically implement it. See, it's fine to write it, but then we also need to ensure that your desires are fulfilled. So you can consider a trust option. And for that, you can personally reach out to us. We can assess your situation and guide you accordingly. Okay. Nitya is asking that if her name has been misspelled for the legal aid certificate, should it be corrected? We always recommend you to get it corrected, because to be honest, you don't know which institution is going to raise an issue. So it's always recommended to get it corrected. Okay, how does the NRI get a will made while being out of India? Oh, it's extremely simple. The process is the same, right? Like, you create a will, you just have it signed, you have it witnessed by 2 people, and it's a good will to go. Probably in your visit to India, you can get it registered. In some nations, you also have the facility to get it registered with the embassy. There are some processes which are there. You can also have it registered outside. But an NRI can easily make a will outside India, even with respect to the Indian assets. Okay, what are the tax implications for a beneficiary? Is it true if I die without a will, the beneficiary is burdened with a huge tax? Actually, the answer, I'll throw a little bit of light on estate duty or estate taxes. In India, we don't have estate taxes or death taxes. So the beneficiary does not have to pay any tax when they receive any asset. They will have to pay tax in the normal sense. For example, let's say if I inherit a flat, only when I sell it off, I'll have to pay either long-term or short-term capital gains, depending on the situation. I will have to pay property tax the usual way, but I don't need to pay any death tax. So as such, there are no direct tax implications when a beneficiary receives any assets. Nirmala is asking, if a property becomes yours by way of a gift deed, do you still have to register it and pay duty? The answer is a gift becomes complete only when you write a written instrument, and only once it is registered and the requisite stamp duty is paid. Only then it becomes a valid gift. Okay, those were a lot of questions. We're so happy to answer questions, and yes, please feel free to keep posting your questions. Meanwhile, I'll take just a few minutes to talk about how yellow can benefit you in such a situation. Essentially, we've created an app, a first of its kind app in India for you to go and make your will. All you need to do is mention some details about you, your family, your property. How is the property going to be passed on, to the various people? And we have taken care of all the legal jargons. So, like one of you mentioned that, what if my later will becomes, what if I mentioned an earlier will, but a later will is also in place? So all these legal aspects, for example, all my earlier wills and codicils become null and void. All those aspects, the jargons we've taken care of. We have a team of lawyers internally. You can see Akansha, she's also part of the legal team. We help you because in case you've got any queries, because we understand that this topic may require some guidance. Although we've designed the app in a very, very simple way. So you can just call us, fix a call, and we'll be there to guide you. And so one is obviously through the app model, that is during the lifetime, you can go ahead, create your will. It's extremely secure. We have banking and financial level security that we ensure. And we also have something called as Yellow Smart, which is essentially smooth asset recovery and transfer. So whether a person has left a will or has not left behind a will, you can reach out to us. And by now, you know all the jargons I spoke about, legal heir certificate, succession certificate, or let's say you need a probate, reach out to us. We've got 500 plus agents on the ground, and we'll help you with every kind of asset transfer in India. And just one last bit I want to mention. We also have something called as Yellow Plus. You can visit our website. I'll display the website details shortly. Essentially, this is a mix of the will creation, the asset transfer, and some insurance related benefits. That is your doctor's visits and diagnostics. Because it was Women's Day, there are some exciting offers which are currently running. We have a tie-up with an insurance company. We're trying to give a holistic well-being package to an individual. So please go and check it out. And with that, I would like to close the session. Please keep your questions pouring in. I'm happy to take any questions. Meanwhile, it'll be great if you can scan the QR code, download the app, and you can play around and see if what we spoke about you can relate to. And of course, for our Aspire for Her audience, we have a special discount of 30%. You can use the code to avail the benefits.
So Aditi, there were questions from Maria and Revati. Does LOT also help in execution of the will?
Yes. So Maria, you can reach out to us, or let's say your executor can reach out to us to help him with the operational aspects of the will. However, the yellow does not act as an executor to your will. But we've got, like I mentioned, the Yellow Plus plans where clients have taken services on behalf of the executor, so that once they're not there anymore, it's very easy for the executor. So you can definitely avail of these services. I think there's, one more question with also how to avail services of Yellow if we need help with drafting of the will and what are the charges. So Revati, what I would request is you can just go through the app and explore. If you face any difficulty in drafting, please reach out to the number that we mentioned here. We have a very strong customer support team which is trained on this particular product. I'm sure they'll answer most of your queries in navigating the app if you face any issue. Otherwise, they'll connect you to us and then we'll see where are you really stuck and how we can help you.
Thank you, Aditi. I think, I think we've covered all the questions. And if there are any more questions, please feel free to unmute yourself or you can type in your questions here in the chat box. So meanwhile, I'm going to launch the second poll. Do you think this session has helped you better understand the concept of nomination and cleared any misconceptions regarding transfer of assets post-demise? So people, please give in your answers.
You guys are making me nervous.
So Aditi, I think you're getting full marks. Do you think this session has helped you better understand the concept of nomination and cleared misconceptions regarding transfer of assets post-demise? So there are more than 75% of people who say that, yes, I have clarity and feel confident. And there are about 25% of people who are, definitely coming in the path of understanding it more. And I'm sure, in the coming sessions, the 22% will also move into the yes category.
Definitely.
So thank you all so much for your time. You have been wonderful audience as always. And thanks for spending this evening with us. I hope, and I'm very sure this session has, clarified a lot of, things around will and lot of, and definitely had busted a lot of myths around misconceptions about preparing will and possession of assets. So looking forward for yet another session from She Knows Money next week. Stay tuned. Do look out for our social media channels for regular updates. You will receive all about what is happening in this spectrum. And do spread the word. Let more women benefit out of these sessions. And thank you, Team Ello, for this wonderful session. Have a great evening.
Thank you so much.